Hi, everybody. We're so glad that you are choosing to join us for this free legal clinic opportunity tonight. My name is Josh Bell. I'm with the One Orlando Alliance. And tonight, our goal is to give you some resources that can help you with issues that you might face as you navigate through your life as an LGBTQ plus person in Central Florida. And I'm joined here by my friend.
Gabriela Rodriguez. I go by she, her, and ella, and I am with QLatinx.
So the goal behind tonight is recognition that as LGBTQ plus persons, we face issues that the average population might not encounter. And so our goal with these series of legal clinics is to look at topics and situations that you might run into where you need either some legal counsel or legal documentation. And we want to make sure that living in Central Florida as a member of our community, that you have the resources that you need to be successful. So today, this particular clinic came about because a member of our community experienced a tragedy. And we're so sad and we're so frustrated that she had to go through what she went through. But we're trying to honor her by making sure that other people in similar situations have other options. And so Gabriella can tell that story much better than I can.
Thank you, Josh, and I appreciate your kind words, as this is something that happens so often, and it's often swept to the side, and it's lost with nothing but memories because of the barriers and the complications that it comes with even knowing your rights as chosen family, along with the frustration and the anger as we try to support and do something. Many of us living our true, authentic lives have been estranged from our biological families, and we find comfort and love amongst one another as our chosen family. For Candy, it was a conversation that was never had and came too late. We have amazing fond memories of her as she strived to use her lived experience to empower and drive others, and that very spirit of resilience and good humor would see Candy through more pain and tragedy than many of us will ever know. The struggles of being able to advocate for her after her passing came with so many emotions and so many closed doors. And while I'm proud to say as a community we were able to lay her to rest and give her a proper farewell, our siblings are dying at alarming rates and we need to do better. And this is why we are coming to the community to be able to equip individuals with the tools needed to begin these conversations within your spaces, to begin asking those questions and being able to talk to your circles about what's the most important things that you need during a time of serious illness or health crisis. Who's going to make those decisions for you when you can't? And what can be done to protect your human dignity and maintain that? These are the questions that we need to focus on. And we hope that this will prompt individuals to take action and to listen to our message, because planning for your needs, for your future healthcare needs, is one of the most caring things that you can do, not only for yourself, but for your loved ones. With so much happening in the world, our siblings are on the front lines and primarily impacted, and it's time to have these conversations with people that mean the most to us. I want to take a moment and express so much gratitude and gratefulness for working alongside some amazing community leaders and advocates that stepped up and didn't take no for an answer and are creating this legacy in her name. So please, let's begin these conversations in our spaces. And I invite you to listen in and to reach out, as this is our time to be able to ask those questions and think about those thoughts and topics that we want to raise.
So this event, this opportunity wouldn't be possible without the participation of some really amazing organizations. And I want to start out by thanking Gabriella and her role working with clients and working with folks and identifying needs. And then also the organization that Gabriella leads is QLatinx. They have done an amazing job in our community. And then CFGALLA, which is the Central Florida Gay and Lesbian Legal Association, is providing some volunteer lawyers for us. And so thank you to Mark Elliott and all who have been involved in that process.
Awesome. Another special thank you that we'd like to make is to Community Legal of Mid-Florida for being able to collaborate and be able to put this conversation together and bring it to the forefront. And then also to the One Orlando Alliance that is participating to be able to amplify this conversation and has been there since the beginning. So thank you very much for your support.
Hello, and thank you for joining us for our presentation on life care and estate planning. My name is Danielle Harris, and I am the Chief Program Officer here at Community Legal Services of Mid-Florida. Also joining me is Lizzie Johnson, our Managing Attorney for our Older Adults programs. And we are here to talk to you about life care and estate planning and answer some of those questions that you may have around this subject area. Throughout this presentation, we're going to touch base on several different types of documents and estate planning tools. We do want to recommend to everybody that no matter what type of estate plan you are looking for, you always consult with an attorney first to answer those questions and talk about your specific situation before drafting or signing any documents. Each person's estate plan can be different based on their specific situation and facts in their life. So with that, I want to actually kick it off and start with that number one question. The most common question is, who needs an estate plan? Lizzie?
Everyone. Everyone needs an estate plan. My advice has been and will always be, if you are an adult and you're a Florida resident over the age of 18, you should have an estate plan. The reason why you should have an estate plan and a life care plan is because you don't know when you're going to die, how you're going to die, what you're going to have when you die, what you will be entitled to when you die, or during your life, what will happen to you, whether you will become incapacitated, have a stroke, be in a severe accident. So you should have a life care plan which speaks during your life and an estate plan which speaks at death.
Everyone needs an estate plan to help with many things, such as reducing stress and anxiety on your loved ones. We don't know what's going to happen to us, whether it's a medical situation or a financial situation, and we may need the help from our family members or friends to be able to navigate those waters with us. And so it's very important that we have documented what our wishes are, who we want to be able to make those decisions. And so that gives our loved ones guidance in being able to make those decisions going forward. It also helps to document what it is that we want to see happen with our assets when we pass, who our heirs are, and how the distribution should be. So very important questions that get answered with the different documents that we draft and we sign. So in answering all these questions and documenting our wishes, what are things that we should be considering in putting together this estate plan?
When you put together your estate plan and your life care plan, some of the things you should consider is your blended family. Is this your first marriage? Is it your second? Is it your third? Are you legally married? Or is this a common law relationship from another state? Because please note, in Florida, common law was abolished in the 1960s. So if you're unmarried, we do not consider that to be a lawful marriage, and therefore your unmarried spouse may not have the protections you think that they have. Another thing with blended families is whether your relationship is a very trusting, loving relationship, or are you estranged? Because those can put strains on your interpersonal relationships within the family, and that may impact your device or your wishes. Another thing to consider is whether you have any minor children, adopted children, or adult disabled children. In Florida, you cannot just disinherit a minor child. If your child is adopted, they're considered to be your lawful child, just like your biological child. If you have an adult disabled child who is maybe receiving benefits from the long-term care or the Medicaid waiver program, getting a large estate may impact them. And so there are special tools that you can incorporate within your life care and your estate plan to make sure that they're cared for after you pass away. Another thing that you may want to consider is whether you have an estranged spouse. Just like you cannot disinherit a minor child, you cannot just disinherit a spouse. Your spouse has elective share rights under Florida statutes. Another consideration is whether you have property located in another state or another country, whether you have property that is titled jointly with other relatives, such as you may have a house that was passed down from your brother or your parents, that can be impacted by your estate plan. You should also consider whether you have beneficiary designations, such as with a life insurance, with a retirement account, or even with your bank account. Whether you have joint assets, such as a joint house or a joint bank account, whether it's in your spouse's name or someone else's name, that has legal significance. Do you have an estate plan in another state? I often have snowbirds who come from another state and they already have an estate plan. Well, if you have an estate plan in another state, most states under the United States Constitution, under the full faith and credit clause, they will honor your estate plan in another state, but you just want to make sure that your assets in Florida or the other state is basically going to be covered in whatever document you choose, regardless of which state you pick. Another significant consideration is estate taxes. Generally, unless you have a multi-million-dollar an estate, you often will not have to worry about estate taxes in Florida, but you may be subject to federal taxes. And another thing, of course, is whether your potential heirs have creditors, because there may be a way for you to plan to give them some assets or to pass on inheritance to them to avoid their creditors.
In taking all of those things into consideration when drafting an estate plan, there are several documents that may be needed or that may need to be drafted. And so we wanted to lay out a list of some of the common documents that you may have heard of and some of the documents that you may need. Sometimes these documents are necessary for everyone and sometimes not. You will see that not everyone may need a power of attorney or a trust. It all depends, again, on your very specific situation and what your needs are. So, again, recommending a reason to consult with an attorney before you draft or sign any estate planning documents, because they are very specific to what your needs are.
Some common questions that I receive from clients are things such as, what is a living will? What is a healthcare proxy? What is a designation of healthcare surrogate? These are commonly listed in Florida Statute 765. They are what we call an advance directive. I often get questions is, can I get a DNR? Is a DNR an advance directive? Under Florida statutes, a DNR is not an advance directive. A do not resuscitate order can only be issued by a licensed physician in the state of Florida. How can I be an organ donor? What happens to my body after I pass? And can I change my decisions later? An organ donor is basically an anatomical gift. We will discuss that in a few moments, along with what happens to your body after you pass away. You can designate someone to handle the disposition of your remains. And can you change your documents later on? Of course, always. Florida has a process for that, which we will be discussing in a few moments.
Well, let's get right into what these documents are and what they include. So you heard Lizzie mention advance directives. And so let's talk about what those are. They are witnessed written documents or oral statements outlining your healthcare desires. And so the typical documents that you see are a designation of healthcare surrogate, a living will, which is also known by some people as the end-of-life instructions, and then documenting anatomical gifts or organ donation. The designation of healthcare surrogate is a very specific document that identifies who you want to make your medical decisions if you are unable to do so. So if you are incapacitated or become incompetent, some people do this in regards to prepping for surgery in case something happens and they don't come out of it with the ability to make decisions on their own. This healthcare surrogate also is able to receive medical information on your behalf, so that way they can make those decisions. There's very specific parts of a healthcare surrogate document that also designate that the surrogate should discuss these matters with you if they are able to. But of course, in a situation where you are not competent or lack capacity, that may not be the case. It is also very important when drafting a healthcare surrogate document that you identify who the person or persons should be given that authority to make decisions over you. Oftentimes, you want to make sure to include an alternate surrogate, because if the initial person cannot act for any reason or chooses not to act, you have someone as your backup to be listed. Without a healthcare surrogate, the default decision as to who makes the medical choices for you, it defaults to Florida statutes. And in that Florida statutes, there is a list of different people or individuals based on what the state or what the law defines as who should make those decisions for you. That's why it's very important to have a designation of healthcare surrogate document drafted, so that way you get to make the choice as to who gets to make those decisions on your behalf, to not allow it to default to what the Florida statutes provides for you.
What are healthcare advance directives? A living will. A living will is basically, it's your end of life wishes. It's when you are either in a terminal condition, end stage condition, or a persistent vegetative state such as brain dead. Under Florida law, the living will is not invoked until two doctors have independently examined you and they both report in writing that you have no medical probability of survival without artificial means. In Florida, under Florida law 765, we all have a right to live and die with dignity. So therefore, you get to decide whether you want your life prolonging under Florida law, you get to decide whether you want life-prolonging procedures withdrawn or withheld, or if you want them to remain. So basically, do you want to remain on the ventilator, or do you want it to be removed whenever that your body is ready for that time to happen? Another important thing is anatomical gifts. Anatomical gift is basically where you're donating part or all of your body to be used for medical research, education, transplant, or some other authorized purpose that's recognized under Florida law. You can do an anatomical gift in multiple ways. The statute allows in 4 different ways, such as designating that you are an organ donor with the partner motor vehicles. Or you can do the special form and mail it to the repository, which is being overseen by the University of Florida Health Department. Another way for you can do an anatomical gift is to make the designation in a will. Or you also can do it by putting it in a writing. I recommend that you do it multiple ways just so that people know that you are an organ donor if that is a choice that you want.
Does the living will include the do not resuscitate order, Lizzie?
No. A DNR, or a do not resuscitate order, can only be issued by a licensed physician under Florida law. Once a licensed physician has issued the DNRO, it will be signed by you and the physician, and is printed on yellow paper pursuant to Florida law. Again, only a physician, not a lawyer or anyone else, can issue a DNR under Florida law.
So over time, there are some trends or some patterns that we've seen in regards to estate planning and different tools that have come about that people may use more often. And so we've listed them here on the screen for you to take a look at, some of which we've talked about and others which we will continue to talk about during this presentation. But we just want to make you aware of those.
Can advance directives be changed? Yes, you can amend your advance directives at any time simply by executing a new version of it. You can revoke it simply by either drafting a brand new one, or you can orally tell someone pursuant to Florida Statute 765 that this document no longer exists. I do not recommend that. As an attorney, I have to believe that you should revoke it always in writing, saying that you revoked the advance directives dated on January 1st, 2020. You also can have advance directives terminated or suspended pursuant to a court order, such as if a guardianship is ever issued on your behalf, a judge may suspend or terminate a previous advance directive. Also, if you pass away, well, if you passed away, the purpose for that document has expired, so therefore the advance directive ends at your death. If you put a specific date in your advance directive, such as saying that it was only valid for 2 years, well, once the 2 years is up, the expiration has happened, so therefore the document is no longer valid. If your agent or whoever you appoint doesn't want to take on that duty, or say that they withdraw, or they're terminating their authority, well, the advance directive, when it relates to them being your agent, is over. And divorce or annulment may impact your advance directive also. It depends on what is going on in your divorce case, whether it was filed, what's the current statute, what's the current case law at the time.
So a lot of what we've talked about so far has to do with medical situations that you may be faced with, or reasons that you may need estate planning and life care documents for medical purposes. And we want to go into now a broader topic of what is a power of attorney, because this is a document that can cover a larger area of financial needs that you may have. So a power of attorney is a legal document delegating authority from one person to another. And so in this document, if you were the principal, the one giving the authority to the other individual as your agent, you would be giving them power to handle specific topics or areas in your life on your behalf. A power of attorney can be limited in its nature, in which the document is for a very specific amount of time. It can be for a specific purpose or only for a specific account. For example, you could say that someone has limited powers to be able to access your bank account and only your bank account. You could limit the authority that they have over that bank account as well. So those are what we call limited powers of attorney. There are also durable power of attorneys, which are a broader form of power that is granted, and it survives your incapacity or if you become incompetent. So this is a document that is very helpful in respect to if you no longer have capacity and you need someone to step in to take care of your affairs. However, this is also a document that you need to be very careful as to who you trust with these powers, because they can lead to someone misusing powers. And so it is very important that the person you identify is somebody you trust, and you really look at what powers you are giving them within the document. So after we have a power of attorney put into place, Lizzie, what can you do if you want to make changes or revoke it or terminate it?
If you want to revoke your power of attorney, such as you may have previously done an estate plan and discovered that you have a power of attorney that you didn't even know that you had, it's very important that you understand that under Florida law, you are now required to revoke the power of attorney in writing. There's an actual process to revoke your power of attorney in Florida Statutes Chapter 709. And you must serve a copy of the revocation on your prior agent, whoever you appointed to be your attorney in fact. Also, anyone you reasonably believe received that power of attorney, such as a bank, a title company, your doctor, whoever you think may have received that power of attorney, they must also be put on notice and receive a copy of your revocation of power of attorney. A power of attorney also is automatically terminated upon your death. So that means that when you pass away, your agent is no longer your agent. They can't be your agent. There's no one there for them to represent. I still get questions, and I still have those questions from agents who are actually still acting under power of attorney after someone passes away. Okay? Another way for it to terminate is if you put in there an end date, such as February 1, 2021. Well, on February 1, 2021, it expires. It will not live beyond that date. If you execute a new power of attorney, that can revoke the old one. If there's a court order where you are incapacitated, then the judge may suspend your power of attorney pursuant to Florida Statute 744. There's a process in there to suspend the POA for an existing POA. Also, you may have put in there a specific purpose, such as, oh, this is POA is only for the sale of my car, but once the car is sold, well, that purpose has been fulfilled. So therefore, that POA ends. If you are divorced or annulled, that will also impact the POA validity, and therefore, typically, once a divorce is filed, then often the POA goes away also. What happens if the person is wait a second. Mm-hmm. I'm trying to figure out.
What we put on there?
No. I read it two ways. It said, what if I am incompetent to make decisions? And I'm not sure if they're meaning as the ward or if they're meaning as the agent.
So before we get to being a ward, so this is leading into the guardianship and reason to have a prenatal.
So this is so the question is really relating to what if I need a guardian, maybe?
Yeah.
Okay. Just trying to figure out how I'm gonna read. Okay. Because usually it's not the ward that calls us; it's the family member.
Right. Yeah.
Okay.
Right.
Okay.
The person who's going to be the guardian.
I got it.
Okay.
Another question I often.
Oh, hold on. Oh, sorry, it's already recording. I was like, wait a minute. Okay.
Another question I often receive is, what can I do if my loved one is not competent to handle their own affairs? Well, under Florida Statute 744, that's the guardianship code. You may be able to petition the court to determine whether your loved one has capacity to make their own decisions or whether they need a guardian to be appointed. Under Florida law, a guardianship, and there's different kinds. There is a limited guardianship. That's where the judge appoints a legal guardian to handle certain affairs for a potential person, which we call a ward. That means that person is incapacitated. And there's also a plenary. Plenary means that they are totally incapacitated. And that typically means that the guardian is going to do most of the things that's authorized under the law for the ward. And the ward is the person who is incapacitated. So it's a multi-step process, and you can call our office because that is a very fact-specific case that we need to talk to you about, because there is ample case law that says it's okay for someone to make bad decisions. Making bad decisions does not necessarily mean that they need a guardian. However, there may be less restrictive means that you can consider asking the court for other than guardianship, such as maybe being appointed as a conservator. That means that you get to handle their finances only, which is a lesser restrictive means than being a guardian over someone. Because when the court appoints a guardian, the person may lose a lot of constitutional rights, such as their right to bear arms, their right to get married, their right to have an abortion, their right to vote, their right to have a contract or enter into contracts, their right to hire an attorney, their right to drive. So therefore, the court is always looking for a least restrictive means. So you can always call our office to discuss your particular situation, why you think a guardianship is needed. Because if one is appointed, then typically it can be a guardian of the person. That's to decide where they live, who they associate with, who their friends are, who can visit them. There's also a guardianship of the property, which means who handles their money.
So there is a way that you can say or have a say in who is appointed as the guardian if one is needed. And so with an estate planning tool called Designation of Pre-Need Guardian, you are able to decide who you want appointed and who you want appointed for what specific tasks. And that can be whether it's over your physical well-being or your financial needs. In that regards, you can also indicate if there are alternative individuals that you would appoint as the guardian if the court found that you were incapacitated and needed to have one appointed.
Another common question we receive all the time is, what is probate? Probate is a legal proceeding where a judge determines the legal heirs for a decedent or a person who has passed away. That's also where the assets are going to be accounted for, or we call it inventory or marshaling. Their assets are going to be valued, and their assets are going to be distributed to their intended beneficiaries of the estate. There's different levels of probate. There's formal administration, which can take at least 12 months or more. There's a summer administration, which is a simplified, quick process, which only takes maybe 3 to 6 months. And there's a disposition without administration for people with very limited estates, and then in a disposition without administration, typically the assets have to be under $5,000, and the decedent cannot have been on any real estate. That means that they cannot have their name titled on any real estate or vacant land. A valid last will and testament often streamlines the probate. A lot of clients think that probate is a bad thing. It is not a bad thing. All it allows, okay, I'll do that one. A valid last will and testament often streamlines the probate process. Probate is not a bad thing. It can be a very good thing and a great tool for many people because it allows the judge to review the will that's being presented. The judge will review the will to determine its validity and make sure that the will that's being presented is actually a lawful will and it's the last will of the decedent. It helps to reduce fraud in the probate process and to ensure that the assets are being distributed to the intended beneficiaries. And again, a valid last will and testament can often qualify for a summary disposition and really only takes months to process.
So what is a last will and testament, as Lizzie was mentioning? It's a document that identifies who you want to be appointed as the personal representative to manage your estate, as well as outlines and identifies the members of your family and specifies who you want to receive your assets of your estate. So in this document, you are able to identify who you want to receive what. It can be one specific item. It can be your entire estate. You can even identify and document who you do not want to receive assets of your estate and put that clearly stated in your last will and testament. You can lay out other special wishes that you would like to express within your last will and testament, and you can create testamentary trusts, which is another tool for estate planning that is used for those that have maybe an individual, an adult disabled child or a disabled spouse that you want to provide for, but want to make sure that you do not prevent them from having the other benefits that they may be receiving outside of what they would receive from your estate.
What if you do not have a last will and testament at the time of your death? You may have lost it. It may have been destroyed, or it may not have, or your loved one simply can't locate it. If there is no last will and testament at the time you pass away, the court will determine, one, who will be appointed to be your personal representative or your executor. The court will determine who are your heirs. That means that who will receive your assets pursuant to Florida law. Basically, when you do not have a last will and testament, the legislatures of Florida has already decided who are your heirs, and your assets will be distributed pursuant to Florida law.
There are ways to avoid probate altogether. So that does not mean that a last will and testament is not important, but there are additional tools that we use in estate planning that can help avoid your family and loved ones to have to go through this process. And so just to name a few, when you have jointly owned assets and they have the right of survivorship on them, those assets go directly to that survivor without the need to go to a court to ask for a court order or require anything additional by way of court process to further that transfer to the other individual. There are life insurance policies you can put a beneficiary on. So if you have a beneficiary on there, and that beneficiary is able to receive the insurance proceeds, then that too is able to stay outside of the probate process and can go through a separate process dealing directly with the life insurance policy company to address those issues and get those funds transferred. Other accounts, such as your bank accounts, your IRAs, annuities, those are other accounts that you can leave beneficiaries listed on. You can also leave accounts with payable on death. So it identifies who that asset should be transferred to upon your passing, and all the individual that is the recipient of that account or of that asset needs to do is go to that agency or that organization that holds that asset, present your death certificate, and go through the process with them directly, which again removes it from the court process. So there are several different tools, and it's very specific depending on what assets you have, your family and current situation, and what choices you want to make. So again, this is another reason why, although there are tools to avoid probate, you want to make sure to consult an attorney to discuss these tools and discuss what is best for you and what steps that you should take.
In summary, what happens if you do not have a life care or an estate plan? In a guardianship, a judge will select your legal guardian, whether it's your loved one or whether it's a professional guardian or the public guardian. It's up to the judge. Again, if possible, do the designation of pre-need guardian, which is your statutory presumption of fitness for your selected guardian. In a probate or your last will and testament, if you do not have one, the judge will determine your legal heirs, select your personal representative, and divide your estate pursuant to Florida law. Medical or health care. If you do not have a written advance directive, then under Florida statutes, a medical health care proxy will be appointed, with the preference first being your court-appointed guardian. And if you have none, then it's going to go to your next of kin, such as a spouse, your adult child, your sibling, your parent, and so on. Financial. Your family may have a very difficult time handling your finances. That includes accessing your bank account, calling your mortgage company, calling your car lender, or anything related to your finances if you do not have specific legal documents written so that your family can handle your financial affairs in the event you become incapacitated or if you pass away. Another common question that I receive is, what happens to my remains after I pass away? Well, after you pass away, your next of kin will be contacted to handle your remains. I recommend all my clients put in writing who they want to handle the disposition of their remains, and if they have any special instructions relating to their funeral, their memorial, or their cremation, such as, I nominate Attorney Harris to handle the disposition of my remains, and my ashes are to go to my son. Or you can say something like, I nominate my wife to handle the disposition of my body and my funeral arrangements. Or you may want to include that I'm a retired veteran. I desire to be buried at the Arlington National Cemetery. I like to include the address and the phone number. If you have a prepaid cremation plan or a prepaid funeral plan, please include that information in your written instructions. Also, if you want to exclude someone, maybe you've been the victim of domestic violence and you want to exclude someone from handling your disposition, you should put down, I exclude my brother, Donald Smith, from handling the disposition of my remains. Another important thing is, if you have a prepaid funeral plan or a cremation plan, you may want to consider adding a rider which covers any travel, such as if you pass away in another state, and your cremation or your funeral is to be done in Florida, there's going to be a fee to travel from whatever state you passed away in or the country you passed away in and get your body back to the state of Florida. Those travel fees can be extremely expensive, so you may want to consider adding a rider so that you can pay at today's rate, which may save your family a lot of stress and a lot of money.
So what are some special considerations for anyone who is not married when you're talking about drafting your estate plan? There are things that you need to take in consideration. If you are not married and you live with someone and you have items that you are sharing in regards to household items or a car, what are going to happen with those assets or those items after you pass? Sometimes our clients ask us about making gifts during their lifetime, and doing that has its own tax consequences that we highly recommend that anybody wants to make gifts or large gifts, they do talk to a tax attorney that can be able to talk about what those consequences are, and that way you can make an informed decision regarding your choices about making gifts. How assets are titled are definitely something that we talked about previously in regards to joint assets. It can happen with bank accounts or vehicles, and something that you need to consider when you are drafting your estate plan and when you're going forward to try to title these assets jointly with someone else or in another format than just in your individual name.
If you are an unmarried couple and the house is only titled in one person's name, when the decedent passes away and the house is titled in their name or vehicle is titled in their name only, the domestic partner's rights to remain in the home or to keep that vehicle may be limited, because whoever is the heir to that house or that vehicle, they may come and repossess or gain possession of that asset and leave your domestic partner without a house or without a vehicle. So that's something that you should make sure is included in your life care plan and your estate plan. Another important thing for unmarried couples is if you have co-signed debts. When you co-sign a debt, whether you're the primary or you're the alternate, when one person passes away or stop paying on that debt, maybe due to an incapacity, the other person is still liable for that payment. So that's something that you have to plan for in your life care plan and your estate plan, is what happens to those joint debts when one person becomes incapacitated or passes away. Another thing that's another special point that you need to remember is under Florida law. Recently, in July 1st, 2015, Florida passed a law that now has a digital assets. Florida passed a law as of July 1, 2015. Florida passed a new law covering digital assets. We all can appoint a digital assets fiduciary during our life or after our death. The digital assets fiduciary, they're responsible for managing your digital assets when you become incapacitated or you pass away. Digital assets are things such as your email accounts, your online bank accounts, your Facebook, your Twitter, your social media. It also includes things like your electronic files that's stored within your cell phone or on your digital camera or your computer. So your fiduciary gets to manage those. They get to determine what happens to those. They have to inventory your digital assets. They also have to value them, okay? Digital assets may have value even when we do not think they have value. Recently, there was an appellate decision up north where they determined that the decedent had a gaming account And in the gaming account, that became a digital asset. Well, they had different property. So I don't know whether it was a sword or a tree or something part of the game. Well, that asset was worth several $1 million, the appellate court determined. So while we determined that this doesn't have any value, it may actually have real value. And that digital asset fiduciary gets to determine what happens to the asset, whether it gets sold or whether it gets to remain in that person's assets. So that's something very important to consider.
So we've gone over several different estate planning and life care tools, and we've mentioned several times the need to consult with an attorney before you draft any of these documents or sign any of these documents. Now with that, when you're consulting with an attorney, it is important that you don't bring third parties or somebody else with you to have that meeting with the attorney. There are confidentiality reasons or attorney-client privileges that you don't want to have broken by having someone else present with you. Sometimes we may see that someone brings a third party, their caretaker or a neighbor or another relative in with them, and it leaves us to question their influence over our potential client. And so we want to make sure that our client is not being held under the pressure of someone else trying to make decisions for them or pursuing any specific estate planning path. And so it's very important that we meet with our clients individually and not with anybody present. So even if you need someone to bring you to the office, it is highly recommended, and likely your attorney will tell you this as well, that third party stay outside of the conversation while you meet with the attorney individually, just the two of you to have that conversation regarding what your wishes are and what you want to put into place in regards to your life care and estate plan.
How often should you review your documents? Every 1 to 3 years, you should review your documents. People pass away, relationships change, they may end, or they may start a new one with a different person. Situations change. You may be divorced. You may have adopted a child. You may have grandchildren move in with you. You may have moved to a totally different state. Anytime you have a significant or substantial change in your life circumstances, I recommend that you review your estate plan and your life care plan and consult an attorney to determine whether you should update those documents to incorporate your significant change in your life. This also includes reviewing your life insurance policy. About 15 to 20 years ago, until 15 to 20 years ago, most people did not have a contingent or alternate person listed on their life insurance policy. But because of change in times, it is now highly recommended that we all have alternate or contingent persons listed on your life insurance policies. I routinely tell my clients to review these documents, and I'm not shocked when they come back and tell me that they had no one listed. So make sure that your beneficiary is who you think it should be and who you want it to be. This is your money. You worked hard for it. So you should make sure your documents reflect that. Also, if you move to another state, please, as soon as you get settled, consult a local attorney to determine whether your estate plan and your life care plan from that prior state is effective in the current state. It's not uncommon for people to present to me life care plans or estate plans that's not always in accord with Florida law, or documents that were not prepared by a lawyer, and therefore it was not properly executed, in my opinion, in their state. So it definitely is not executed correctly under Florida law. And therefore your assets and your beneficiaries and your loved ones are not protected.
So we hope that this presentation has provided some clarity, as well as you may have some questions that follow from this, and what do you need to do next? And so we would ask that you give us a call here at Community Legal Services of Mid-Florida. And there's our number, and you can access us online through an online intake or our chat system to be able to go through an intake process to determine eligibility and see what we can assist you with, and at least answer those questions that you have before you make any decisions. Now, our pro bono team currently has some clinics set up for February 2nd and February 16th from 3 to 5. And if you are interested in meeting with somebody on one of those dates, I would recommend that you contact us at the phone number provided, 321-270-7711, or use the link to access our online application and set up an appointment to attend one of those virtual clinics to meet with an attorney to discuss your questions and your life care and estate plan.
Hi, I'm Mark Elliott. I'm a civil rights lawyer in Orlando and a member representative on the One Orlando Alliance. And I wanted to share with you a few extra resources that may be helpful to you. In addition to the wonderful legal services that are provided by Community Legal Services of Mid-Florida, there's also the Legal Aid Society of the Orange County Bar Association in Orlando. And Legal Aid Society provides, among a lot of other services, attorney-assisted name-changing services. Also, Equality Florida has fantastic name-changing resources and specific instructions for those of you that are more comfortable in the name change process, doing that work on your own. And finally, CFGALLA, Central Florida Lesbian and Gay Law Association, will offer once a month Ask a Lawyer drop-in sessions at the LGBT Center in Orlando and in Kissimmee. Once COVID-19 restrictions are lifted, volunteer attorneys from CFGALLA will resume attending those once a month Ask a Lawyer sessions. Thanks.
Good evening and hello. My name is Monique Keels. I am the managing attorney of the Legal Advice and Brief Services Helpline at Community Legal Services of Mid-Florida. First, I'd like to thank One Orlando Alliance for allowing this opportunity to share what it is that we do on the helpline and how we serve our clients throughout Central Florida. Now, when our clients reach out to us, they are often very deeply frustrated and fearful over the legal process. They need encouragement and reassurance as well as legal help. And sometimes that includes simple tasks like correcting court filings or documents and other plain language resources. So this is where the helpline steps in. We are what you would call the legal emergency room of CLSMF. What we do is allow our clients to reach out to us through different methods, through our phone lines, through our online applications, and through our chat feature to help render legal advice to them in different areas like housing, consumer, family law, and other related cases that are pretty much in accordance with our mission as a firm. Now, in other instances, we can also refer cases that come in through our helpline to other units within our firm for what we call extended services. And that also includes life and estate planning as well. What we have to offer is a group of knowledgeable and trusted attorneys who are generalists in many different areas of law. We offer bilingual assistance for legal help. We have an English and a Spanish line, as well as interpreter services that are available to help us relay legal advice, information, and other resources as necessary. So how do we do this? We first complete what's called an intake, to determine eligibility for each of our potential clients before we render advice. We then provide pretty much a consultation, a legal consultation with regard to their legal concern. Now, here's where our process gets interesting. What we like to do is holistically serve our clients. As you could imagine, there are so many times when our clients have multiple legal issues going on at one time. And what we try to do is help them unwrap those legal issues one by one and navigate them through each, refer them when necessary, and provide them with empowering tools to solve those legal issues and to make it more manageable for them. And in some cases, what we can do is draft really simple motions that basically provide our clients with, additional time in their court cases. Or sometimes they can even stop adverse rulings against some of our clients. We also pride ourselves on providing legal research, to our clients with regard to the interesting concerns that may present themselves. And as stated before, we always direct our clients to additional sources of assistance, because what we find is, although they may be calling in for a legal issue, there are other social issues that they may need assistance with, whether it be housing or medical issues. It really truly runs the gamut, and we pride ourselves on making sure that each client or customer who reaches out feels like they have received something of benefit when we end the phone call with them. Our whole purpose is to empower each client through their process. And hopefully this provides you with some insight into what it is that we do on the helpline. And again, I'd like to thank you for joining us tonight. It's been really wonderful to share how we can serve and assist you. And remember, we are just one phone call away at the helpline at 1-800-405-1417. Or if you would like to take advantage of one of our clinics, you can feel free to qualify or sign up to meet virtually with a pro bono attorney about your life care and estate planning needs as well. You can use a link or call us to make an appointment. And that phone number is 321-270-7711. And these appointments are available specifically for February 2nd and February 16th from 3 to 5 p.m.